Let me share my screen, and we can begin. Okay, so these are the three lectures that I'm going to do today, tomorrow, and Saturday. Complexity today is complexity, legal systems, and the law of evidence. And tomorrow, probability, and then the third day, the single most important new development in the United States, which is the challenge of electronic evidence. Now, let me tell you why I'm doing these three lectures. I was asked to talk about foundational questions, about advanced issues, and so on. And the two most important foundations to that kind of topic are the first two lectures. I hope you have gotten something from me in these lectures over the last 20 years. I've gotten something very important from you. You started thinking about evidence as evidence science. We thought of it as evidence law. There's a subtle difference between those two things. And your focus on evidence science, in part coming from how you combine forensics and evidence together closer than we do, made me think about what I had been doing and what I had been doing since. And it really is a science. The single most important contribution to a civil society is the rule of law, and the rule of law is completely dependent on accurate fact finding. That in turn is a matter of science, of knowledge, not of just opinion and rhetoric. And so you made me rethink my what I was doing, and in a very helpful way. Now, if one thinks about evidence as a science, not as just rhetoric or rules or this or that, again, the two most important perspectives on that are these first two lectures. What's happening across the world, actually, in all kinds of different sciences, is the implications of complexity. So the first lecture today will be complexity, legal systems, and the law of evidence. In that lecture, I'm going to ask you to think about how you think. The second most important foundation to this science is probability, both its potential, but even more importantly, its limits. And so that will be tomorrow. And then we are facing in the United States, and eventually the entire world will face this, a real challenge to our legal system in the form of electronic evidence, artificial intelligence, and what's called machine evidence, machine learning. And so I thought I would focus on that on the third lecture. Now, interestingly, these first two lectures are part of my research program. The third is not. And so we're going to explore that area a little bit together. All right. So that's the layout for the next couple of days. So here's lecture number one. Let me move this out of the way a little bit. Complexity, legal systems, and the law of evidence. And here's what I intend to do. After some preliminary remarks, I'm going to discuss the limits of formal logic and deduction, demonstrate the complexity of some of our objects of our inquiry, extend the idea of complexity to the legal system. The point being, as I say here, that each of us, whether you know it or not, we are dealing with what are called complex adaptive systems. I'm going to discuss the implications of this point and the significance of the emergence of a new subfield here, which is of complexity, which is evidence science, what you all convinced me we were actually talking about. Hang on, I want to do one thing here. Sorry about this. I just want to adjust this. Okay. So this is what we'll be doing today. Now, I I want you to think about what you have been doing. And I'm going to ask you to think about how you think today. And different disciplines do a lot of different things for a lot of different reasons. What I'm going to suggest is the commonality across all these different areas of thought, including evidence science, but other sciences, is complexity. By the way, some people think that complexity theory is the single most important advance in science since the general theory of relativity. Now, here's where things get interesting. And I will be talking about this. The queen of sciences, the king of sciences, is particle physics. That's what people think. Particle physics operates in a certain way, in a highly deductive fashion. You have assumptions, you verify them, you deduce outcomes, this and that. This is the way you probably approach the law of evidence. And I'm going to suggest it's not very helpful, that we have to think of a different way to think about our discipline, of which many other disciplines are doing the same thing. And that your implicit idea that the science of particle physics captures science is false. It captures an aspect of science, but not the entire thing. And what I'm going to argue and present reasons for you is the best explanation, the best understanding of government, generally, any government, yours or ours, the legal system, yours or ours, or trials, is actually as a complex adaptive system, not as something that looks like particle physics or where you can do controlled studies and the like. Just as an example, I'll come back to later in the day. Everyone worries about errors at trial, which you should, excuse me, but errors at trial are just one part of a much more complex dynamic. You also have to ask the effect of trials on primary behavior and the reflective manner in which these two relate to each other. Another example of the limits of thinking about things in a deductive fashion rather than from the point of view of complexity is trials, at least our trials. And that you have to realize I'm talking from my perspective, which they are actually not conducted in the way you might think that they are, with just discrete rules of evidence that determine admissibility and exclusion, and then you deduce from the evidence outcomes. That's not what actually happens. What actually happens at trial is it's an example of what's called a form of inference to the best explanation within the context of an adaptive system, trials itself. People adapt to each other. They react to each other at trials. It's not a rule-driven, top-down deductive structure. So here's what I've been getting at. There's a critical difference between static and dynamic systems. A static system is like particle physics, where you send a whole bunch of electrons running around an accelerator, see what they bang into, and then you just look at the results and deduce your outcomes. Or chess, it's a static system. Now, it's complex, but it's static. It doesn't change. Think of the difference between that and a dynamic system. Systems that do change. This is I don't know who's writing on this, but stop it. A dynamic system is something like a river. It changes constantly, or a rainforest. Much of what we do in the law is more like a rainforest, and I'm going to use the metaphor of a rainforest versus a tree farm, than it is like a tree farm or chess or whatever. I have no idea where these lines came from. Does anybody have any idea? Okay, well, we'll just ignore them. Now, your mind is probably hardwired to think in terms of rules and theories, and this is what I want you to start thinking about. The way in which you think. So, tell me if I'm wrong, but think about that. You search for rules, you search for general theories, you want things in a deductive fashion. That's the opposite of what we're going to be talking about today. The opposite of that is complexity, where things are not in that kind of format. but rather are responding to inputs all the time. But again, as I say, I'll talk about a rainforest here in just a second. Why do we think that way? Well, I'll tell you exactly why. Because generalizing about a complex environment can facilitate control and survival. If you're on the savannah in Africa and your kids wander down to the river and get eaten by crocodiles, your DNA is probably going to pretty soon be wiped out. And so the idea of generalizing and rules and deductions is probably hardwired into our thinking, and it's very effective, right? The conventional view of legal work is rules, deduce outcomes. Let's change the rule, then we'll get a certain outcome. Economics uses utility maximization, and this approach can be really, really powerful. I want to see if I can get rid of these blue lines. I have no idea why this is happening or why that's on my screen. I really have no idea. Oh, well, we'll just ignore it. All right, so, and you see the impact of thinking like things like particle physics as a science within the laws. I was just saying, there's the search for explanatory theories and rules, and you don't really pay much attention to the environment. But here is the key key point. There can be a mismatch between an analytical or cognitive tool and the problem. And the limit on rules and deduction and so on is complexity. So here's the example I always use. There's no one alive who doesn't believe that where a molecule of water is in this mountain stream and where it's going to go is completely determined by physical forces, completely determined. There's no argument about that. But no physicist would say that it's a question that we can study. Where is some molecule of water going to end up? It's impossible. You'd have to know the mass and momentum of all the other particles around it. You'd have to know where the bird's going to fly by and swallow that particular molecule you're interested in. It's just way, way too complex. So on the one hand, this reducing things to simple rules and deductions and so on, tremendously powerful, the queen of sciences, particle physics. At the same time, it has its limits. And that's what I want you to think about. So now, in fact, everyday life isn't easily subjected to this kind of approach, but for an interesting reason. It's more complicated than what we call about science. When you think about everyday life, you think about everything that goes on and think about the possibility of reducing that to algorithmic form. It's simply not possible. Here are just two quotes that make that point. Now, so here is what I was getting at before. The difference between tree farms and rainforests. The difference between a static and a dynamic system. A static system is one that is limited, has a limited number of variables that interact in known ways, and you can influence it in the way that you want to influence it. So a tree farm, the point of a tree farm is either to grow Christmas trees or to produce lumber. You know exactly what the purpose of it is, and you know how to affect that outcome, how to bring it about. If there hasn't been enough rain, you water. If it needs fertilizer, you fertilize. If there's a fungus, you use a fungicide. That's an example of a static system that's subject to your control. But think about a rainforest. What's the point of a rainforest? There isn't a point to a rainforest. It's subject to all kinds of innumerable variables. You can't not only say that there's no purpose to it, you have no idea what will happen if you interject some new variable. I don't know if you have this problem in your country, but we have it in ours, where people release animals in the Everglades, which are like a rainforest, like pythons. And it turns out these pythons are ruining the rainforest. Rabbits released in Australia almost killed all the vegetation in the entire continent. This is an interjection of a variable into a complex system with unpredictable results. So this is where we start thinking about complexity science, not like particle physics, but the science of complexity. And what we're dealing with, this is a quote from Melanie Mitchell, and I'll give you these references here in just a little bit. A complex adaptive system is one in which there's a large network of components, no central control mechanisms, maybe simple rules of operation, but even if they are, they give rise to very complex collective behavior. Or as Neil Johnson says, the study of phenomenon which emerges from a collection of interacting objects. It can arise in the absence of any controller. So what are we talking about here? Well, let me back up. I would take a screenshot of this slide if I were you. And I'll pause here for just a second. Here's the book by Melanie Mitchell. Here's the book by Johnson. These are all books. The Santa Fe Institute is an institute that's dedicated to the study of complexity theory. Here are some articles of mine and some co-authored that show the implications of complexity theory for legal decision making. So here are some resources for you. So as I say, take a screenshot of this if you like. I will also make this video, even with these strange blue lines, I have no idea where they came from, available to you. Now, you've probably heard the term chaotic systems. A chaotic system isn't chaos in the sense you normally use the term. Quite the contrary. A chaotic system is a completely determinate system. It's not indeterminate, but it's sensitive to its initial conditions, and it undergoes nonlinear transformations. It's not a linear progression, and this is what a chaotic system is. What complexity theory deals with is chaotic systems, but then have emergent properties. Things emerge out of these chaotic systems, like, for example, your immune system. There's no central control mechanism in your immune system. Somehow your immune system is able to keep you alive against the onslaught of numerous bacteria and viruses that would like nothing more than to kill you. Things emerge. And then the third aspect here is what I call catastrophes. Again, doesn't mean catastrophe in the normal sense. It means an unpredictable input. So, for example, the point of this is these are not amenable to top-down reasoning. Let me give you a real-world application of this. A guy named Lorenz, a famous meteorologist in the 50s, was trying to create algorithms to predict the weather. Very important aspect of life, actually. And he created a simple model with 12 differential equations. One day, he did a run with solve these 12 differential equations, and you would get a result. One day, he wanted to just go recheck a prior run of this system, and he got completely different results. And what he realized is he had rounded off one of the initial inputs from 6 decimal points to 3 decimal points, a very, very small change. When you made this one little change to these differential equations, predicting this complex system, you got this result. Now, what does this mean in real life? This is what it means. Changing a very, very small initial input. The first run suggested at a certain date and time is going to be heavy rain. The alternative one is going to be sunny. Now, variables in real life are infinitely complex. You can have decimal points that go on forever. What does this mean? What this means is there is never going to be a science that can predict the weather very far in advance. Now, this is a perfect example of a complex system. What's the perfect example of an adaptive system, or emergence, or catastrophes? when a meteorite hit the Earth, it wiped out the dinosaurs. Had that not happened, you and I would not be sitting here today. Completely unpredictable external effect that caused completely unpredictable emergent properties. Now, this idea of a complex adaptive system is a frame of reference. You can decide what it is you want to talk about. I, for example, just used the example of the immune system that is a perfect example of a complex adaptive system, but so too is your body, of which the immune system is a part. Maybe the most spectacular of these complex adaptive systems is your mind, which has allowed humanity to exert astonishing control over his environment. But these are frame of references. You can say, this is what I'm analyzing. Now, these are everyday examples of what I'm talking about, and I'm about to get to the law in just a second. How your body grows. I mean, these two cells come together, and all of a sudden, you know, arms and legs and eyes and ears start appearing. Traffic on the roads, a perfect example, unpredictable and subject to unanticipated inputs that cause emergent properties like roadblocks, like heavy traffic on the roads, market economies, infectious disease, but also these things: markets, elections, common law, litigation, and trials. These are also examples of complex adaptive systems. Now, you might be thinking, well, what is he saying? You can do things without computation, without reducing things to controllable variables? Well, the answer is yes. Let me just give you an example that I like to use, just to show that you can control or deal with almost an infinite amount of information without any computation, without any deductive structure whatsoever. The growth of the Industrial Revolution was driven by spinning, weaving cloth in England. And to produce cloth, to produce the different kinds and grades and this and that, you needed a constant source of information. Of energy. The energy came from the steam engine. The trouble with the steam engine is it didn't give a constant source of energy. It was variable. So if you were thinking about this as a computational problem, this is what you could do. In other words, you want to keep the flywheel that's generating, that's producing the energy for the looms that are weaving all this cloth. You want to keep that at a constant rate. Now, what you could do is you could measure the speed of the flywheel, compare it against what you want it to be. And if there's no discrepancy, you'd have to start all over again, because the energy coming from the steam engine varies as the basis of the heat generated by the boiler, by the atmospheric conditions, by whether there's any steam lost in the system, and so on. So you have to keep doing it forever. If the desired speed is not what you want, then you have to return to, you have to measure the current steam pressure, calculate the desired alteration in it to speed up or slow down the flywheel, make the adjustment, and then you have to return to step one and start all over again forever. Now, this is a very costly process, a computational process, but a costly process. What Thomas Watt figured out was called a centrifugal regulator. He created this mechanism where he attached these two balls that are hanging out like this, and the regulator goes around like that. And when the flywheel speeds up, guess what? These centrifugal forces these up. That immediately conveys to the valve to close, to slow down the flywheel, and it adjusts itself instantaneously. Now, what's actually happening here is an infinite amount of information is being transmitted instantaneously without any computation. So it's just an example that you can think and do things other than by rules and deduction. Now, what I think, another frame of reference I use here is what we're talking about is the difference between bottom-up systems where things you're dealing with a complex adaptive system in various ways versus a top-down system like particle physics. Why bottom-up systems sometimes work better is if you have vast amounts of information, like trying to regulate that steam engine, you need a way to deal with things that defy computation. When you add feedback mechanisms, like the centrifugal regulator, you can sometimes do that. And that's why markets work, why the common law works, and things we'll get to in just a little bit. The problem is this idea of thinking about things as complex systems is not we call it a panacea. It's not a cure-all for everything, because you do get those unpredictable emergent properties, and then you have to have a way to deal with them, and that's where feedback mechanisms come in. So here are examples. I'm starting to turn my attention to the law now. That within the law, a perfect example of a complex bottom-up adaptive system is the common law. No one thought up the common law. It emerged, you might say, naturally at different nodes across England and then the United States. And you have these feedback mechanisms that when the common law does something wrong, you have these feedback mechanisms that say change it, or when it does something right, other parts of the country can adopt it and so on. So it's a complex system. In the common law, judicial decisions, legal decisions, they ripple out across what's basically a neural network that are formed by the citizens who can, as I just say, react to it, adapt it, constrain it, whatever. And then doing this for this further litigation, and you get something that actually begins to look like your immune system. And that's why I think this analogy is so interesting. Eventually you get some stability, and off you go on to the next problem. This is a pictorial example. This is a real neural network. This is what a brain looks like. This is what the internet looks like. All these interconnected nodes. There's no top-down regulator. There's nothing in your mind, a top-down regulator that regulates what your mind does. It is your mind that does those things. And it does so from the perspective of the interactions of all the neurons. The way the internet works is exactly the same way. I don't know if I don't have time to go into it, but the internet is a perfect example of a complex adaptive system. Now, here's the point. It looks to me that the legal system is more like a rainforest than a tree farm. It permits fluid accommodations between too many variables to even identify, let alone compute. So when you think about regulating that, and that's here in the second half of today's lecture, where we're going to talk about the law, that's what you're doing. You are regulating through the law of evidence this complex adaptive system. Now, in my estimation, I don't know about your system, and I want to hear from you in the second half of today's second hour today. But from our point of view, what you have is exactly that. These are also models of the common law. And this is what actually my research explores. Some of those articles on that screen of sources, this is what they're doing. They're exploring these things and their implications for legal decision making. Now, for those of you who may want to pursue this, I just want to caution you that there are two kinds of networks out there in the world that people study. One, social networks, like Facebook. The other is neural networks. Social networks investigate the relationships between people, like how many nodes, a person got a PhD by showing that the probability of me knowing you, anybody sitting in this lecture today, if we go down 6 what are called nodes, like I know somebody, that person knows somebody, that person knows somebody, that person knows somebody, that person knows you. Probability is almost 100% of any two people in the world being able to be connected by 6 different nodes. Quite remarkable, really. Although when you think about it, it's not so remarkable. I know a lot of people in China. I would find somebody who knows somebody where you live, and if not, somebody who knows somebody where you live, and they would know somebody from your neighborhood, and eventually, boom, there's a connection between you and me. That's not what we're talking about. This is not social networks. This is not Facebook. This is not the interconnectedness in that sense. What we're talking about are neural networks that generate emergent properties through a bottom-up process. Now, there are adaptive systems of various kinds, obviously. Australia almost being destroyed by rabbits was an example of an adaptive system, a pathological one, but that's the problem. These things can become pathological, just like the law can become pathological. You inject a new rule, a new law, a new statute, and it does not have the effects that you think it's going to have. Perfect example of what I'm talking about. So this is a critically important point here. I am not being dismissive of formal approaches as a general proposition. Physics is stunning advances in physics, stunning advances in medicine. A lot of those are algorithmic or top-down deductive sciences, and it's very, very powerful. But there's a critical difference between most of what you think of as sciences and evidence science. The sciences that you think of as of sciences can pick the problems that they study, and they study problems that are themselves resolvable. Go back to my point about a molecule of water going down a mountain stream. No physicist is going to study that problem because they can't. It's just too complicated. So they don't. So instead, they send electrons whizzing around an accelerator and having them bang into protons and see what they get. It is as much as we think of physics as the queen of sciences, it's the most simple-minded approach of all time. It's just electrons whizzing around an accelerator and seeing what results from the collisions that occur. Tremendously powerful in terms of not exposing us to but tremendously powerful in terms of increasing our understanding of this particular problem, but it is simple-minded. And and the most important point here is physicists do that because they can. Let me give you the example I like to use. No one asks for grants in the physics world to study what happened before the Big Bang. I think that's a really interesting question. Where did the Big Bang come from that caused our universe to come into being? But nobody asks for funds to study that because it can't be studied. There's an impenetrable barrier between us and what happened before that moment in time, moment in space, moment in space-time, whatever you want to say. Now, this is maybe the single most important point. Whoops. For me to make in this first half an hour. The legal system, evidence science, does not have the luxury that other sciences have of picking its own problems. The legal system has to deal with whatever comes along. You can't say, well, we're not going to deal with that problem. It's too difficult for us. It's too complicated for us. It's not the sort of thing we want to do today. So you go away. Don't bother us. Those of you constructing your legal system have to deal with whatever it is that is generated by the entire range of human affairs. So the point here is to be clear from our point of view, your point of view, our point of view, what the problem is. The problem is constructing a system that's going to interact with all these other complex systems and allows us to adapt to things as we go along. So you probably all wondered if I was going to get to evidence theory today. Well, let's think about complexity theory and evidence and look at evidence law through the lens of complexity theory rather than through what has normally been the approach, which is to look at evidence from an epistemological perspective and ask, how do we generate knowledge? And does this rule help generate knowledge? That's all very helpful. It's also very, very constrained and limited. Why does this matter? The point I made in my introductory remarks. without accurate decision making, however one gets there. And when we're done today, if you thinking about the law of evidence as a law of rules rather than thinking of it from the perspective of complexity is better, then that's what you should do, because nothing is more important than factual accuracy in resolving disputes. Every single right that you can think of is utterly dependent on accurate fact finding. Well, let me back up. Let me give you an example. Property. Property is the right to possess, consume, dispose, and control an item. Very important property right. When that property right is contested, a fact finder, not a lawgiver, is going to decide that the world was on a certain day in a certain condition where either you or I found, made, were given, or bought that item. Those facts are going to determine which of us has the right to this property. Every single right that you can come up with is utterly dependent on fact finding. It's exactly like that. So when I talk to people like you are the ones who are creating the conditions of a just society going forward into the future. But but now we get to the problem. How do we say ex ante, a priori, before you hear a dispute, you have no idea what the dispute is going to be about, what the issues are, what the right is that's going to be litigated, a combination of different rights. You have to construct a system that can deal with this complexity. There are two kinds. Computational complexity, which we can talk about, has a certain implication, and real life complexity. It's real life complexity that we're going to be talking about today. How you construct a system that that allows one to deal with all these complexities about human affairs that you obviously see in your life and I see in mine. As for computational complexity, we're not going to deal with that. We can talk about that later on. You can't do, and I'll talk about this tomorrow. This is the essence of tomorrow's talk. You can't. Whoever is talking, mute yourself. Whoever is talking. Henry or Benson, are you on? Would you ask people to mute themselves?
Yes. 也请大家把那个声音都是关掉啊，千万不要说话啊。然后 Professor Allen, can you add me as a co-host so I can help you adjust this?
Yeah, how do I do that? Do you know?
Just to find my name and click right and add me as a co-host or something.
Mute, stop, spotlight, make co-host. Okay. And Henry, do you have any idea where these lines came from? Was somebody writing on it or something?
Yeah, seems like someone accidentally put some anecdotes there. If I'm a co-host, I can try to.
All right, go ahead. Try to do what you can do. Let me pick up where we were. We'll be talking about probability tomorrow, but that's not what I want to talk about today. And what we're going to see is that the complexity of human life defies computational capacity. You can't do a probabilistic analysis of trials. That's just a point which we will expand on tomorrow. All of the work in the law of evidence that tends to look like reducing real life complexity to computation. This is work I hope you know about, argument and scenarios, scenes, the Bayesian analysis. These are all post hoc. They're all done ex ante. Ex ante analysis of evidence is unhelpful to legal analysts constructing a system. I'm sorry, it's ex post, not ex ante. It's all ex post. It's all after the fact. It's ex ante that the problem is. You need to construct a system before you know what the problem is going to be. That's ex ante, not reconstruct it ex post. Wigmore charts the same, probability, all the same thing. So what's the point? It's the law and the human condition. Unanticipatable problems, computational complexity, all kinds of things going on. Now think about, again, you all probably think about evidence as a set of rules. I'm going to try to inculcate, we say, create the thinking that instead the legal system is best thought of as a complex adaptive system. So let's start talking about complexity. Evidence isn't just a set of rules. You derive it from a theory of litigation, which itself is derived from a theory of government. That's why you have different evidence law than we do. You have massively overlapping forms, thank you, Henry, massively overlapping forms of regulation that interact in unpredictable ways. What do I mean by that? Well, you have different jurisdictions that actually overlap. Your city has its laws, that's overlapped by your province's laws, that's overlapped by your we would call it federal, your national laws. You have all different agencies regulating things in different ways. The reality of the legal system, at least in the United States, and you can tell me it's different in China, but I'm an expert in the United States. It is, as I say, are massively overlapping forms of regulation that interact in unpredictable ways. This is the reality of what it is that you legal analysts who are essential to the construction of a just society are dealing with. Within that context, what do you see? Social and legal systems aren't static, they change, right? The behavior of people changes over time. The legal system changes over time because it has to react to these behavioral changes. And that's why I say the reality here is the legal system is a complex adaptive system with interconnected nodes that reacts to new systems and runs on what we call inference to the best explanation. This is how we decide issues. We don't decide them algorithmically. And you may differ here from us. We decide them by telling the parties, you have to give us your explanation. And then we're going to decide which explanation is better, and that explanation is going to win. Or the fact finder can say, well, having heard the two parties, here's what I think happened, a little different, and that's what is going to win. How does this work? By exploiting massive parallel processing. That was my point of the pictures of the internet and the neural network. That really is an example. Those are metaphors for our system in the United States of the common law. And again, remember, rules work great in certain contexts. They don't work great in other contexts, and you have to make a decision. Is this the right way to approach? What cognitive tools do I want to use to resolve this problem that I am facing? In the United States, what's interesting is you think of the United States as having complex exclusionary rules. That's actually wrong. The rules of evidence are almost all rules of admission, not exclusion. And what they encourage is what we call relative plausibility. That's the idea that the parties articulate their stories, their explanations, and then we decide over those explanations. By the way, what am I doing here? What I'm talking about is the foundation to the law of evidence, just to be clear. Now, let's think about more complexity. Then just think about errors. One of the most important issues in the law of evidence is regulating errors, right? Burdens of persuasion, excuse me. Now, that's critically important, I agree. Treat the civil parties equally, so we have preponderance of the evidence. Skew errors against erroneous convictions, so we have proof beyond reasonable doubt. Critically important variables, no doubt about it. They are also stunningly limited. All the things you've learned about these burdens of persuasion just about are false. And what's most importantly false about it is the idea that what you're trying to do is regulate errors at trial verges on the absurd. Now, why do I say that? You're the legal analyst. You're creating the system. You've been told in class that you've taken and this is and that you have to focus on errors at trial. Well, okay, I agree that's important. It's important, but it's one small part of a much larger dynamic. What happens at trial affects who goes to trial. You make a decision whether to litigate something, to resolve something by litigation in what we call the shadow of the trial. So you see results, you may have a really good case, but what you see is for some reason people in this set of cases, like jurors and judges, just don't understand it. And so you're going to lose. If you're going to lose or think you're going to lose, then you're going to settle. Or if you think it's too costly, you're going to settle. That will generate a lot of errors. Now think about it. You can't just focus on errors at trial if you're a sensible legal analyst. You have to think of the interaction between trial errors at trials and errors at settlement. And what about cases that aren't settled, that are never brought? In many instances, a case may not be brought, not because it's not correct, not your position is not because your position is not legally right, but because you just can't win. It's just not worth it. Those are all mistakes. So when you talk about errors, it's not errors at trial. That's one small part of a much larger dynamic, but there's more. What are all these things that you're doing with here supposed to do? Well, it's supposed to optimize litigation behavior. You have been taught. We're going to optimize means make the best use of what happens in litigation. But there's two kinds of behavior: litigation behavior and everything else. And everything else is what I call primary behavior. Well, guess what? There's an interaction between litigation behavior and primary behavior. A rule comes down that's going to be a rule of evidence. What happens? People out there in the real world, well-informed people, but people out there in the real world have to respond to it. That affects their primary behavior. If you can't win a certain kind of a case, you will avoid the kind of activity that leads to that case. So that's just an example. But here is what the problem from the point of view of the legal analyst is. It's not just that. Whoops, I keep clicking and goes to the next slide. It's not just what you've learned in evidence class, errors at trial. It's all of this, a huge, huge optimization problem. When you write a law of evidence, okay, you ended up writing a law, fine, it's a discrete rule. What should underlie it is this kind of thinking. Now, here is just more examples of complexity. Again, go ahead and take a screenshot of this, but this is a well-known article. I'm pretty sure you know about it. What we demonstrate in that article is that, and a whole bunch of stuff that's been going on for 15 years, actually, that's the culmination of a research program, that what actually goes on at trial is not probabilistic, a simple rule of probability, preponderance of the evidence is a 0.5, more than a 0.5 probability and the like. What we have established is, in fact, what goes on at trial is an idea of relative plausibility, where, as I was saying earlier, the parties provide their explanations and then you decide over it. Think of another complexity. One of the things you were taught and have been taught is that relevance can be given a probabilistic account. Relevance is determined by whether a proffer of evidence, a piece of evidence, increases or decreases the probability of some material fact being true. It's a very useful heuristic. A heuristic is a way to think about things. It's also false. You have no idea at the point at which a piece of evidence is introduced whether it's going to increase or decrease the probability of a material event, because that piece of evidence is in a contingent relationship with all other evidence. Until you hear all the other evidence, you can't make that judgment. So what instead happens? What happens is a piece of evidence, a proffer of evidence, is said to be relevant if it's part of a party's explanation. Now, it turns out, by the way, there's another interesting implication here. If the meaning of relevance is a proffer of evidence, I'm going to not keep saying piece, the proper term is proffer. If a proffer of evidence to be relevant has to increase or decrease the probability of some material fact, then proffers of evidence the parties agree on would not be relevant. Well, that's crazy. Most offers of evidence, proffers that evidence, are duplicative. The parties agree on. They agree something happened, I was there, he was there. They disagree on very small pieces of the overall puzzle. the evidence that structures that problem is not contested. So it doesn't increase or decrease the probability of any material fact. Well, what does it do? It allows each party to tell the story the way they want to tell the story, and then you compare them, and then you see what you have to decide. This is the reality of trials, at least in the American system. Now, think about the rules of evidence. You all probably have been wondering tonight for you, and for me, it's morning. The sun is just now coming out. That they provide a blueprint for inference, but that's impossible for the reason I just went through and another. Relevance is an interaction between the life experiences of a human and what's presented to their sensory perception. Here's a deep point, and it's critically important. Most of the information that you would say determines the outcome at trial is not presented in the form of evidence at trial, but exists in the brain of the decision maker. It's the interaction between the very limited testimony and the very limited documents and exhibits and so on, and how that interacts with your background and experience. That's what determines relevance and thus determines the outcome at trial. Now you might say, how does this, wait, Professor Allen, we have learned that you have all these complex exclusionary rules in the United States. Are you just saying, that they're useless or they don't exist? No, I'm saying that view is wrong. The two complex exclusionary rules that are focused on and critiques of the American systems of litigation are the hearsay rule and the character evidence rule. When you actually look at these rules, they are not rules of exclusion, they're rules of admission. The hearsay rule in our system, has some 40 exceptions to it. Depends on how you count, but around 40. 40 exceptions to an exclusionary rule? Well, it's not an exclusionary rule. It's a rule of admission that was generated against what we call the backstop of the English common law of hearsay, which was an exclusionary rule. The American experience has been, with only one exception, for 200 years, cutting back the scope of that exclusionary rule through exception after exception after exception. To today, essentially what you have is any relevant evidence in the form of hearsay is admissible. Any evidence that matters is admissible. Present sense impressions, anything a party says, adopts, authorizes, any statement at all, civil or criminal cases, is admissible against that person. Not for them, you can't create evidence, but the other party can use. These are just examples. Excuse me, character evidence is similar, not quite as extensive, but it's the same thing. There's so many exceptions to character evidence that there's one way or another to get it in, almost always. Now, what does that mean? The reality in the United States is you have this adversarial process that runs under the idea of relative plausibility, and the primary regulator of evidence is the trial judge. Now, is that good or bad? Well, we can talk about that if you want. Now, why does all this matter? This is what I've alluded to a couple of times. This is the point about law of property. Without accurate fact finding, rights are meaningless. By the way, no matter what conception of a right you might come up with, you might think that the law should do social things, like when I've been to China almost 30 times doing lectures, and I make points like this and people object. Well, no, we're not a capitalist system. We're, a socialist system, and we're trying to, raise up the poor and do this and do that. Okay, fine. You still have to get the facts right. If what you do is going to hurt the poor, well, your right has not been vindicated. Any conception of a right is utterly parasitic, dependent on fact finding. And I've already talked about property, and that's just a perfect example of it. Now, here's the point in our system. It's not a set of discrete rules, but a complex set of considerations to be optimized in the context of all the matters I've discussed today, and there are others. Now, this is to some extent a summary of what we've talked about. Trials are dynamic, they're not static. There's no blueprint that is followed perfectly in every detail for a trial. Again, I'm talking our system. I'd be interested to hear what you think about your system in a few minutes when I finish this up. Parties respond to each other. A witness says X, Y, and Z. Well, that person's then cross-examined. That leads to the next witness who is responding to the first or asked to respond to the first by the lawyers. And on you go. What happens at trial is not static, it's dynamic. Think about this point. We talk about rationality a lot. There are dozens of different ways of thinking about rationality. Means end rationality, utility maximization, remaining true to your commitments, furthering morality. I mean, all kinds of different ways to think about rationality. It's not just one, it's not just means and rationality, it's not just microeconomic utility functions. There's lots of different variables. None of these ways of thinking about things are forbidden at trial. None. You can present the case the way you want to present it. You can argue to the fact finder the way you want to present it. A few discriminatory approaches are not allowed. You can't use racial discrimination and things like that. These are very, very minor. So what's the point of this? At the very start of the process, you see tremendous complexity. I referred earlier to the scenarios and argumentation theorists. They've created really interesting taxonomies of the structure of arguments, the structure of scenarios and the like. Very interesting, and none are forbidden. If you want to make an argument about a scenario or you want to use a certain argumentative structure, again, unless it is essentially in our system racially discriminatory, you can do it whatever you like. There's no regulation of that, and the trial judge isn't going to stop it. And as I said before, evidence, I said this about relevance, but the deeper point, what I said about relevance is it's determined by an interaction between you and what you observe. The deeper point is actually this one. Evidence is an interaction between the cognitive processes and what that person is observing. This, by the way, is spelled out in one of the articles in that slide of resources. If not, it's called A Theory of Evidence by me in Northwestern Law Review in about, I think, 1994. This is why you can't a priori ex ante construct things as though it were a system of rules with deductions and so on. We have a few more slides and then I'll stop and we can talk. What you can do, and what evidence theorists in the United States have been doing, is reconstructing things after the fact. Okay, that you can do. That doesn't help decide the next problem. That might be interesting, it might be useful, and it is, but it doesn't create an algorithm to be applied to the next case. The next case is going to be idiosyncratic, unique. Tell me if I use words that I shouldn't. So one last set of points. It's not just admissibility and exclusion of evidence that you're dealing with. The law of evidence does so much more than that. When you think of the law of evidence, what you think about is the epistemological problem, the significance of facts. Okay, that's important. I agree that's important. Remember our discussion of errors. Yeah, errors at trial matter. Of course they matter. But they matter because they're in a complex relationship with other things that are actually more important. It could be the case, just to give you a wild thought to think about, it could be the case that a terrible legal system that always gets things wrong might be socially useful. Why? Because of the effect on primary behavior. If you know that the legal system is terrible, it's not going to work, you're going to avoid it. The way you avoid it is by following the law, constructing your primary behavior in such a way that you don't have to litigate. Litigation can be what we call a dead weight loss. It's not, I don't think, but it can be thought of as a dead weight loss. It's like pouring money, and what we say, pouring money into a rat hole. It's just gone, doesn't do anything good. I think it does do good, but you can think of it that way. And if that's what you think is going to happen, you're just wasting all these resources. You're going to avoid it. So facts matter, but facts themselves are complicated. The law of evidence, together with the law of procedure, and you all argue about whether evidence is procedure or not. I think that's a stupid argument. It is what it is. You have different things you have to do. You have to structure the process, and then you have to decide cases. There's nothing that turns on whether something is, quote, procedure in some abstract theoretical way versus evidence in some abstract theoretical way. It's a completely stupid argument, and you should just disregard it and then go about creating the system that you want to create. When you do that, you're going to see that the law, what we call the law of evidence and procedure, organizes things. It allocates power between both branches of governments, all three branches of government, actually. If whoever writes the rules of evidence controls more of the outcome. So you have a struggle between courts who might want to write rules of evidence and legislatures who might want to write rules of evidence. You also have power relationships between the parties at trial. A rule of evidence that says, or law or whatever, the party has discretion to do X, limits the power of the trial judge. A rule that says the trial judge has discretion to do X limits the power of the parties. There's a complex interaction between both at the highest level, branches of government, and at the trial level, litigation level, the participants, that is organized by the law of evidence. The governance problem is what I've been talking about previously, the interaction. A lot of rules of evidence are explicitly designed to affect primary behavior. So you have to think about how you want to organize these things. There are other problems we have. Well, you do too. You have the social problem. What about trials as performative events? Think of the trial of Bo Xilang. I don't know if that's still current in China or not, but that was theater. That was drama. And you have what's called the enforcement problem. When you write a law of evidence, guess what? It's going to affect a complex adaptive system. You think of writing rules and then people are going to follow the rules. Well, that's not what actually happens. Sometimes they do, but what actually happens is people adapt to the rules. That adaptation may result in completely undercutting the implications of the rule that you want to impose on that system. So you have to think of this as an interactive process. Okay. A complication that I've only alluded to, which I will not go into further, I'm about to end this talk, is the relation between what we call substance and procedure. Just so you know, and we can talk about it in the question and answer period, those two interact. It's not just one is, again, not this is substance, that's procedure, and people follow the law. If I don't like what's going on in trial, I can change the rules or I can change the substantive law. In the United States, an example of this is police want to stop cars. The courts say you can't do that randomly. The police want to do it randomly. Put pressure on people not to have guns and drugs. Courts say that could be discriminatory. You can't do it. The response was to create a vehicular law of vehicles, car driving law. That means you cannot drive in the United States without violating the vehicular law. There are too many of them. You have to be a certain distance from the center line, a certain distance from the curb. You have to put your blinker on at exactly the right time. If the police want to stop somebody, all they have to do is follow them. They'll commit an offense, minor, but still justifying a stop, and then the police can do what they want to do. This is an example of the substantive law completely destroying the implications of the procedural decision. So you have this complex interaction as well. So here's what I've been talking about. The law and evidence is not a tree farm, it's a rainforest. It's a complex adaptive system. All those things we talked in the first half an hour today about complexity and complexity theory is the way that you need to think about your task of constructing a just society. So this is the slide I showed earlier, but this is what I do actually, and tomorrow, today and tomorrow. This is what has generated my research program. Viewing the legal system as a complex adaptive process. It's a bottom-up process. It's a bottom-up process with feedback mechanisms, to be sure, which helps, and that's how you try to regulate it, like the centrifugal regulator. We look at these from the perspective of neural networks, not social networks, and what one sees is adaptive systems of many, many different kinds. But this isn't magic. It requires work. Complexity is, as I say, complex and unpredictable. Emergent properties result, and so you need to keep looking at your system from this perspective and figure out the way to nudge it, not to control it, but to nudge it in the right direction. Okay, thank you all for listening. That's all I have to say today. I'm going to stop my screen sharing, if I can figure out how to do that. Here, I need to go here. All right, I don't think, am I still sharing my screen? I don't think so. Okay, ladies and gentlemen, we have 50 minutes. I'm happy to talk about anything that you want to talk about. Benson, Henry, Frank, I don't know who else of my former students are on online here. Is there anything you want to say about what we've talked about or questions that you want to ask?
Okay.
Professor Allen, can you hear me?
Yes, I can.
Okay. I agree with you. The evidential reasoning and evidence decision making in the court, all of the complexity. My question is, if this process of the evidential reasoning or decision making in the court, or for the judge, just like you said, evidence is an interaction between the fact finders, connectives,
cognitive, yeah, their brain,
complexity, and what is presented. My question is, if so, how can we challenge the traditional legal education, or how can change the courses of the evidence, not just the evidence law, is how to arrange or redesign the law courses for the future lawyers and judges. Thank you.
That's a very, oh, sorry, are you done, Benson? So that's a very important, are you done? I didn't know if you were done or not. Are you done? Okay, I assume you finished your question. That's a really important question. And what I try to do in my class, a number of you have been in my classes, what I try to do in my class is start to get people to think about how they think. That's the point of today's lecture, that students, especially young students, come into most classes in any context thinking they're going to learn a bunch of rules, learn a bunch of facts. They have to memorize those facts, and then they have to spout them out, or give them back on the final. That's what is got to change. We have to, especially in the law, have to start inculcating into people's thinking that they're not just going to memorize a bunch of rules. What they're doing is managing or trying to manage society. That management, rules can play a part, but those rules are going to have unpredictable consequences, emergent properties like we talked about today, and you have to think of it from those terms and from that perspective. So you don't just write a bunch of exclusionary rules and expect things to work. What you do is you pay attention to what goes on over time. That's, by the way, Benson, you're the one who convinced me to think about this as evidence science. That's what I was doing, as you know, even though I wasn't thinking of it in those terms. And that's what I've continued to do. So you have to be observant over time. You create a law of evidence, a rule of evidence, whatever. That's just the beginning. Then you look and see what happened. Then you maybe adjust it again. So you think in terms of these rules and get people to think in terms of what they're doing as managing and adjusting, not creating top-down deductive structures like the law of evidence to memorize. So that's, I don't know if you want to respond to what I just said, but that's what I think, which is why with this class that I'm going to start teaching next Monday, I'm going to do a lecture very similar to today's to start the class, because I want them to think about how they think. Do you want to respond, Benson?
I think so. Yes, I think so. Thank you.
All right, there's a hand, but before I take David's hand, Henry, Frank, do you have anything you want to say? I mean, these are my former students.
Yes. Thank you very much, Professor Allen, for giving me this opportunity to talk. So this is not my first time listening to your complexity theory and the relationship with the rules of evidence. And I agree with you with your lecture. And every time I got some new reflections after hearing it. So today I have two thoughts. The first one is, so according to the nature of complex adaptive system, and we both agree that the judicial fact-finding process is one of the complex adaptive system. So I'm thinking the nature of complex system. First, we should have like multiple nodes in the system rather than just one node. Another one very important is effective and efficient transmission of information within the system. And the last one is the feedback system in the system is very important in order to make sure the system functioning healthily. So I'm thinking to apply these very important elements for the system into judicial fact finding. It seems to reflect that we should have multiple nodes. That means maybe multiple factor finders is from the systematical high level is better than just one factor finder.
And by the way, can I just say, Henry, that may be right. I mean, that's, if there is an advantage to juries, it's just what you identified. And that is, you have multiple fact finders that have to agree. You know, they have to share their experience. Now, I want to be clear. I'm not saying juries are better than judges. I'm saying that on the point that Henry has just made, Shuo Wang has just made, they may be. There may be other considerations as well. So sorry, Henry, go ahead.
Oh, no problem. Yeah. Also, like the Chinese judicial system already started to reform on the direction of multiple nodes in fact finding as the people's lay assessor system, but it's just not that effective yet, right? It's still working, trying to fix it. So another point is the effective and efficient transmission of information between and among these nodes are very important. So that probably means the current Chinese people's lay assessor system is still need to improve because the current system that does not have a very effective and efficient transmission of information among these factor finders as the lay assessor system. So they need to keep on improving it. And the last point for my first comment is, so feedback system is very important for complex adaptive system. That
Extremely,
yeah, so
extremely
yeah, so to reflect into the judicial fact finding, I'm thinking the feedback system, not only talking about a trial, but also maybe the appellate review system as a feedback system, maybe very important. We should pay more attention. So that's my first.
Yeah, I think that's exactly right. So I'm sorry, go ahead. You have more
Yeah,
to say.
my second thought today is, as you lecture suggested, basically two fundamental different way of thinking here. One is deductive thinking. That's kind of our human nature, hardwired. We cannot resist to think in the deductive way, or we can think in the legal context, it's the formal approach, it's the approach of rules. And another fundamental different approach you keep on lecturing and tell us is the nature of the reality is a complex adaptive system, and we should try to start thinking in this complexity theory. So in the first few times when I listened to your lecture, I kind of naturally thought these two approaches are contrasted to each other. But the more I think about this, and it seems like the best way we should do is actually to combine this, to have both of these thinkings, and trying to design and to have it in a compatible way. But then I thought, Professor Allen, of course, is right, because we kind of naturally already have this deductive thinking, no matter what, like we naturally have it. So you emphasize the complexity theory. But now the question for us is, when we know we need to have both, but then how to mix them, fuse them together in a compatible way. That seems to be the next important question. Thank you.
Yeah, I agree with that, Henry. Deduction is a really valuable tool. So is induction, right? So is abduction. And my arguments today and my discussion today should not be taken to mean deduction is out, we're never going to look at it again. It is exactly to free the mind to realize there are other tools than deduction, other tools than writing rules, other ways to look at the world. And of course, in that way, these other ways of looking at the world, all these cognitive tools can be useful. They can be useful at different times for different problems, which means you have to decide, you have to think about how you think. Remember what I said at the very beginning. You need to think about how you think, and then how that maps on relates to whatever the problem is that you're addressing. So yes, I agree entirely with you. Do you want to say anything in response? Then I'm going to ask Frank if Frank has anything to say.
Oh, I'm just very happy to hear your feedbacks, and I will keep on going on this direction. Thank you.
Frank, do you have anything to say? Turn on your.
I have no question. Thank you, Professor.
Okay. So anybody who wants this to ask a question, and you can ask. Let me be clear.
Okay, I think that Debbie have question. She has.
Yes,
raised.
I see that. But
okay.
Before I call on David, let me just say to everybody, you can ask questions about anything. Okay, anything that interests you about the American legal system, government, whatever. It doesn't have to be about this particular lecture. You can use this as an opportunity to ask whatever you might want to ask. So right now I see one hand, David.
Hi, Professor Allen. It's great to see you again. Remember
Nice
me?
to see
I was
you.
your TA last year. It's happy to
Yes.
see you again online, and happy to know the class will start next week. I have a short comment and a question. Short comment that according to your lecture, I find that accurate truth is critical to justice, but there's no way to find the ultimate answer. So the
I'm
goal,
sorry, could you say what is, I didn't get the word, what is critical to justice? Accuracy.
accurate truth.
Yeah, accuracy, right.
So, but there's no way to find the ultimate answer. So the goal of evidence is to reach a dynamic balance between the accurate truth and the complex society. That's my point. Maybe wrong, but my
No, I
question is
agree.
here. My question is about the field of evidence scholarship. So in China, there are actually two trends in evidence scholarship. As one end, that's what CUPL does to integrate the interdisciplinary studies like forensic science, psychology, economy, and all these interdisciplinary explanations of evidence. As the other end, some scholars, especially Professor Yan Yu from Tsinghua University, he says the field of evidence law should focus on rules, especially admissibility. His main point is that the judicial proof is too complex and it's beyond our lawyers' expertise. And the more we know about the judicial process, the more we don't know. That means these studies, interdisciplinary studies, will not help us improve the rules. So in your opinion, so which way shall we follow?
So did I understand you to say that this second way, they're saying the more you look at the other sciences like CUPL, that does not help you decide what rules to have?
I think maybe I get him wrong. The more we know from the interdisciplinary studies, like the psychology explanation, economic explanation, the more we don't know because it's a complex system. We cannot understand the complexity. And this understanding will not help us improve the rules. So that makes no sense. So we should not go to the interdisciplinary direction.
I think the latter point is just false. What that view, not yours, not CUPL view, but Tsinhua's view, seems to say that we should write rules in a state of ignorance. That's just clearly not a sensible thing to do. The more you know that you don't know, the more you're able to influence it in a positive way. How can you, if you don't, if it's almost like the approach you're talking about is afraid of learning things, and that they should forget about learning things and then just write rules. But what's justifying the rules? So I think what CUPL is doing and is quite consistent with what I've been saying today. And you should not be afraid of knowledge. You should want to learn about economics, sociology, criminology, forensics, and then see whether or not what you think is occurring out there in the real world is optimal. And if not, can you adjust it? Not adjust it in a deductive structure that you're sure is going to solve the problems, but try to nudge it in the right direction. So as I understand the Tsinhua approach, I think it is not the right way to do. I don't understand how you can think you can write good rules in a state of ignorance.
So one last short comment. Because my postdoc doctor project is a psychological foundation of evidence law. So that's the reason why I asked the question, how to put this knowledge into rule making.
Right.
Maybe I can write email to you later. Thank you.
No, yeah, sure, that's fine. You can email me, but I think that's exactly what you should be thinking about. That is human psychology, these cognitive practices, how they relate to the real world, and then again, how we can manage it, right? Not regulate it, but manage it. Think of in terms of nudging things in a certain direction and seeing what happens. So I'm all in favor of that. I would also say, though, that the psychological study should also be informed by economics. This point I went through about errors, right, and the relationship between errors at trial, errors of settlement, cases not brought, primary and litigation behavior. Those are really important too. And so I would think you might want to expand your thinking beyond just the psychological questions, which are really important, and I agree they're important, to other areas. I may mispronounce the name, John Yao, is that? I don't speak Mandarin, my apologies to everybody.
Yes, Professor Allen. I have a question to ask. It's my first time to listen to your class of this complexity of evidence, and I'm wondering that the complexity of evidence. I read your article, the plausible, that's the theory, and I want the major question I want to know is what kind of contributions this research can lead us to the future reforming of U.S. lawmaking policy or making more rules of evidence. What can your theory leads us to? The major directions I want to learn.
So yes, now first, let me be clear. My work is, I view myself as a scientist, not as it's not normative. I'm not saying this is the best thing to do, this is not the best thing to do. Yes. My work is trying to explain what I observe. Okay?
Yeah, exactly.
So you're asking a normative question. What are the normative implications of what I observe? Well, first of all, your legal system may be different from mine. So hopefully, by looking at these things that we've done in the United States, that gives you a perspective to look at your process and see what you think it is, right?
Yes.
Your process may be entirely different from ours.
Yes.
If it's not, and there are real cognitive limits here. I mean, I don't see how any system can actually proceed probabilistically. It's got to proceed on the basis of plausibility for reasons that if you say you've read our articles, Okay, that then means does your system enhance or retard that process?
Yes.
What you have done, does it encourage the creation of explanations and the probing of explanations, or does it retard it? And if you think that, whichever direction you want to go, if it doesn't encourage it, then you want to write your rules in a different way. You want to try to figure out ways to encourage the construction of explanations and the presentation of them at trial. Now, one other point that I didn't get into, and if what we are saying is right, the trial judge in our system is critical. Our trial judges may be different from your trial judges. Your trial judges are increasing in professionalization, as I understand it, but I also understand they have a long way to go.
Yes.
You may not, you look at what we have talked about, and now you look at your trial judges, you may not want them making the discretionary calls that we allow them to make in the United States.
Yes.
So that leads to another interesting problem. The training of trial judges, the training of judges generally, but trial judges in particular. So these are, whether you think this is useful or not, this is what I suggest our work opens up for examination.
Yes.
Go ahead and respond.
Thank you. Well, a lot more to learn from your research. Thank you,
Okay,
Professor Allen.
you're quite welcome. Jiayi Zhu, is that how it's pronounced? Am I butchering all of your names? Again, my apologies. I'm a stupid American. I speak English, and that's all that I speak.
It's so good to see you, Prof. Allen.
Nice to see you.
I'm Jia. I'm a statistician, and part of my research interest is the forensic statistics. And it's very fortunate to come across this advertisement of your seminar. So my question is, because I have been looking for an interesting topic and fruitful field in the evidence science or forensic science, and I cannot compare. I'm not sure because after listening to your lecture today, I have just a feeling that comparing to forensic science, evidence science is more. Let me put this way. Can statistics contribute to evidence science as it does to forensic science? Like when I did some literature review about the reference in the decision-making field, I read Bayesian network might be a promising tool in decision-making, and that's related to evidence science. Is it a promising area?
Are you done?
Second question.
No, you go ahead. I go ahead, finish.
Second question, and I'm also very excited about your lecture tomorrow. Is there any? Can you give us some spoiler before tomorrow?
Yeah. So my spoiler is going to be that trials conducted in the United States are not probabilistic events. They're not data driven in the way that you are talking about or that you work with all the time. They are, and I'm going to explain why. Probability theory, of which statistics is a subset. Statistics is a subset of probability theory. Why there is only limited utility. Now, the reason for that is what you operate on are relative frequencies, right? DNA, forensics, fingerprint, this is all relative frequencies. Those are the statistics that you're talking about. In most areas of life, you do not have anything remotely like that. You have experience, not relative frequencies. That's why the thinking is not probabilistic, but based on plausibility. Now, the challenge, and again, I don't know how much I'll talk about this tomorrow, but the challenge for forensic science is you actually are creating knowledge. The scientists are creating knowledge. We have more and more knowledge about DNA. We have interesting studies about fingerprint identification in the United States. You probably do as well. A whole series of forensic techniques. The problem is integrating that kind of knowledge with the kind of knowledge that people actually use in deciding and navigating human affairs. That's the big problem. That's why your system wants to go to Bayes' theorem. Okay. Right. You want to go to Bayes' theorem because you think that gives you an algorithm. But the trouble is that algorithm only works on objective relative frequencies. It does not work on subjective creedal states. There's no reason to think a subjective probability approach is going to enhance accuracy. So that's the big problem right now. And I admire what you're doing, and we can talk more about this tomorrow. But the big problem is integrating the formal structure of knowledge from forensic science, where you actually have a science, which means you have data, with a non-data driven way in which most trials proceed. That's the problem right there. I'm sorry, go ahead. Does that help?
I see, because there's a famous last words in statistics is in God we believe, all others must have data, must bring data. Yeah.
Right.
So
sorry, go ahead.
So it is much safer or to stay with forensic science than to step into the evidence science. Is that?
Yeah, that's the problem. And even with data, this may be too technical for many of the people on this call, but even with data, you still have to know the conditional probabilities. You have to know the dependency relationship. You can't just do a DNA analysis without knowing the likelihood that the DNA was deposited in different ways at the scene of the crime. The DNA standing alone tells you nothing, right? Exactly. That's why actually doing things in that fashion is literally impossible. And that's why, and I don't know if you get into these debates in China, that's why the forensic scientists are trying to go towards subjective probability. Do you know about this, subjective Bayesianism?
We currently focus on the likelihood ratio and score-based likelihood ratio to avoid the impact from the prior.
But is that likelihood ratio always formed by data or by subjective beliefs?
It still have impact on, yeah, I agree.
Right, so that's the problem. I mean, and it's a really important problem, and I really admire what people like you are doing, but it can't capture yet, maybe someday it will, but it can't capture yet what actually goes on most of the time, where you do not have any data-driven analysis whatsoever. You have people's experiences and what they think, and this is and that's, and you can view that as a form of data, a type of data, but it's not in a relative frequency form. So as a result, you can't put it into a likelihood ratio of the kind that you use and should use. So think about these things. Will you be here tomorrow? Will you be at the lecture tomorrow?
Yes, definitely. Yeah.
So I'm going to talk, I'm not going to go great into detail about this particular problem, but I'm going to be talking about probability. Because that is, look, the two things that matter the most are viewing things through the lens, for evidence science, are viewing things through the lens of complexity, and then the role that probability theory plays in that process, including what you're talking about.
That sounds great. Sounds great.
Tom, Tom, are you my teaching assistant for this class?
Yes.
Hi, Tom. Nice to meet you.
Yes. Hi, Professor Allen. My name is Tom, and I'm your teaching assistant for this year's course. And I would like to ask two questions. The first question is whether the primary behavior you mentioned can be understood as a reaction of human behavior caused by litigation. And the second question is that in a complex adaptive system of evidence law, since it needs to pay attention to the interaction of various subjects in the system, I think how to reach consensus in the interaction process and whether the consensus can be reached is a key issue. And in the last few questions you mentioned, or in the last few problems you mentioned, the relationship with other branches of the government is also involved. As far as I know, it is not only related to the upper and the lower levels of the court, but also to the Congress and the executive branch of the court, of
Right.
of the government. As Justice Breyer noted in Making Our Democracy Work, a judge's view, This also requires a consensus, only a consensus on constitutional democracy, not a consensus within the legal system. It's like heart, the heart, talking about the internal perspective versus the
right.
external perspective. Thank you.
So yes, on the first point, you ask about the relationship between primary and litigation behavior, and whether or not primary behavior is in reaction to litigation behavior. In part, of course, in part, not always. Much of your primary behavior is completely, we say, oblivious, unconcerned about litigation behavior. When you go to the movies, you're not thinking about litigation behavior, right? When you have to decide what to have to dinner, you're not thinking about it. But in many instances, you are. When you're constructing a business, or you're thinking of signing a contract, or whatever it might be, you do that in the shadow. We say the shadow of the law. The law is looming over you. And so there is that interaction, but it goes in both directions. Primary behavior can affect litigation behavior as well. And the important point is to see that as an interaction that is going to be affected by, going to be regulated by, results are going to be caused by whatever rules of evidence you articulate, you construct or create. So so yes, primary behavior is affected by litigation behavior. Litigation behavior is affected by primary behavior. If you don't break the contract in your primary behavior, you don't get to litigation, right? So obviously there is this interaction. It goes both directions. Your problem as a legal analyst is to think about these things globally and figure out what kind of mechanisms, again, you want to employ to try to nudge things. And this is the most important idea, nudge things in the right direction. And then, like I talked about earlier with, I forget who it was, then observe what happens and see if you're getting the results that you want to get. So that's question number one.
Yes.
Question number two is on these complex adaptive systems are structured by complex, and not to use the term twice, interactions of many different variables, right? That was your point. And can you get to consensus about them and how to regulate them, I guess, is what your question is. You in China worry about consensus much more than we do in the United States. I don't think consensus is a necessary component. It might be great if you get it, but much of what we're talking about will be experimental. You don't know what the result's going to be. So you can't have real consensus. You might have a consensus on what to try. So I would view this as a science, again, where you are collecting knowledge over time. You're observing the things you want to observe. You're observing their interactions. People may disagree about them. Well, and then you try something and see what happens. So I would really strongly encourage you to think about this as a glorious experiment of constructing a just society. Now, that involves, when you can come to consensus, that's great. That should not be the objective. The objective should be to get things right. There may be dissenters on that. Well, then you listen to them and you structure experiments, you structure an intervention to test it and see where you come out. So again, we're not so concerned about consensus in the United States. Hongwan Zhao?
Hello, Professor Allen. Yeah, I have a question. I remember in 1996, you put forward a educational model to defer
Deference.
deference in scientific evidence reviews.
Right.
My question is present the adopt rule is hard. Daubert rule. It's hard for the adopt rule to give a great feedback to distinguish the differences between the fact founders' interference and scientist interference. I think maybe from your educational model, maybe that can give a great feedback. But I think it's hard for us to use that regular mode to reduce the cognitive basis between the scientific process and the litigation process. So I gonna to know in the present Allen, Professor Allen, how to solve that dilemma situations, how to reduce that cognitive basis in the scientific evidence review.
So what Mr. Joe is talking about is my critique of the use of expert testimony in the United States, my criticism and examination of it. And the point that I made there was actually related to what we've talked about today, although I didn't use these terms, which is that trials in the United States are not probabilistic events, they are educational events. You're not updating a probability through scientific evidence or anything else. You are learning about something for the first time. That's why we structure our trials the way we do. Well, now, if an expert is brought to trial and the expert offers his or her opinion about something related to the trial, the fact finder has no way to judge the truth or falsity of that opinion. By definition, they don't know enough about the subject matter, so that's why you have an expert in the first place. That injects a foreign element into decision-making. That foreign element is the opinion of the expert to which the fact finder can defer. What defer means is the fact finder accepts that opinion without understanding the basis of it. And that's what Mr. Joe is talking about. Now, in my opinion, the United States model here is not a good model. Is not a good model. That experts should not be allowed to express their opinions. They should be required to educate the fact finder sufficiently so the fact finder can understand itself the implications of the knowledge, the implications of the data. So that's what's going on here. And frankly, Mr. Joe, that's exactly what I think should happen. That you should not allow experts to come into trial and just say, well, the plaintiff should win, in my opinion, because the defendant was negligent. That should not, that's a radical example, but that should not be allowed. They should be required to explain themselves in a way adequate for a reasonable person to understand. Now, let me be clear. That is not required in the United States. And this is in my opinion, a mistake that we make. Having said that, in reality, the parties, the lawyers and the parties know that if you can actually explain the opinion, you're better off. And so the structure of litigation in the United States, it allows a deferential model to be employed, but the reality forces the parties to try to have the expert explain and educate the fact finder. So to some extent, that offsets the negative implications of the way in which we employ expert testimony. But if you just look at the Daubert case, like you were referring, right? Daubert, the Daubert rules, and this is and that. The rules of evidence in the United States allow the parties to present an opinion without the underlying basis for the opinion. In my case, that's, in my example, in my opinion, that's a mistake. Now, some people say, but come on, these people are laymen. You know, the judges and jurors are laymen. They're not specialists. You can't educate them. Well, if you can't educate them, then you shouldn't try a case in this way. It should be decided in some other way, administratively, legislatively, but not this way. Because if the fact finder really cannot understand what the expert is saying, that almost guarantees an irrational response, an irrational decision. So, Mr. Cho, am I responding to your question or not?
Yes, I'm sure. Another question for your opinion. Do you agree the doubt rule is mixing up the scientific test and reliability? Because the professor Susan Huck, she also has that opinion.
Right. Yeah, no, she and I agree on a lot of these things. So yes, I think it is mixing them up. But again, the effect is to let the parties decide what to do. And the most effective way, just everybody who's still on this Zoom call, the most effective way to present expert testimony is to make the expert explain why they are saying what they are saying. So the formal defects in the formal problems with our expert rules are offset somewhat by the pressures that the litigation process imposes on the parties to produce explanations that can be understood. I want to be clear, I'm not saying this is optimal. I don't think it is optimal. I would not allow, if I were in charge, which I'm not, I would not allow experts to testify on the basis of an unexplained opinion, an opinion that they do not explain.
Yeah.
Mr.
Yes.
Yu, you're back again.
Yeah.
Yes, dear Professor Allen, to this question, I learned that in US that both parties hired their experts for their interest. This is kind of conflict of interest to the evidence theory.
Yep, that's right.
How this problem can be changed.
So what you're saying is exactly right. That's part of the problem. Yeah. that parties and in the United States, I hate to say it, but in the United States, you can hire an expert to say anything you want that person to say.
Yes.
No matter how strange or weird or unusual. Now,
yes.
Note what I was saying to Mr. Cho. If you don't require an explanation, then the fact finder, judge or jury, doesn't matter. The fact finder is just going to have these opposing opinions. That's why I say we should require them to explain their opinions. Once they start explaining their opinions, then you can understand what they're saying and decide who's telling the truth and who isn't telling the truth. That's exactly right. Now, the alternative to this, let me be clear about something, because you all do something that I also do not approve of. You all have essentially official experts. Your judges select the expert. Well, that can have the same problem. Whoever the expert is that is selected by the court or whatever is going to decide the case. But how do you know that expert's telling the truth? There are interdisciplinary, we call them interdisciplinary disagreements within the field of economics or psychology or whatever. People disagree about things. If I get to pick the expert in a context like that, I'm going to get one side of an interdisciplinary dispute. I'm not going to get objective truth. So there's a constraint.
Yeah. That's the problem.
Yeah, exactly. So we have problems, you have problems. All of this goes back to one of the early questions by the forensic scientist, whose name I don't remember. this is a deep problem, which is why, but tomorrow we're going to talk about probability. This is a deep problem. The use of different forms of knowledge and how one can integrate it into a trial process.
Thank
You want to
you.
respond? Yeah.
Thank you, sir.
We have time for one more question, if there is one more question.
Thank you.
Yes, I want to have a question. Dear Professor Allen, I want to know, how do you think Susan Heck criticized your legal probability? And I want to know your feedback. Thank you.
Susan Hack did not criticize my work. She actually says she has come up with a similar argument independent of mine. And that is the limits of probabilistic reasoning and the problems with expert testimony. So her critique is of probabilism. It's not of what I call relative plausibility. So I don't think Susan Hack and I disagree on much of this. I mean, there are disagreements of details and things like that, but not much. In fact, in one of her articles, she actually says what I just said, that what she's arguing is very similar to what I had previously argued, but she says she came up with it independently. That's a little bit of ego on her part, but there isn't much of a disagreement. Now, if you think that's wrong, you can respond and tell me, but that's, I think, her view. We're both critics of subjective Bayesianism in particular, and of probability and the use of probability, the overuse, the too much use of probability in general. So Ms. Guan, do you want to respond or not?
I want to know, just Susan Heck use his fundamentalism to just like epistemology, not a science. 对 yes, not a science. She told me that the law is not a science, just a rule. So I don't know, how do you think the 2 points different of you? You see, well, again, the side, yeah.
No, you go finish. I thought you're done. Go ahead and finish.
Yes. First thing is that Susan Heck seems the law is not science, but you see the law is science. So she used the fundamentalism to judge the evidence, but you use the science to judge the evidence.
Yes, but actually, I don't, when I say evidence, when I use the phrase evidence science, I'm referring to what we as legal scientists do. Her critique of what goes on at trial, which is what you're referring to, it's not a science in that sense, but you have these rules of evidence, is right. What I'm saying is you need to think about those rules of evidence from the perspective of a scientist. I don't think she would disagree with me. She has this idea of epistemology called
fundamentalism.
Fundamentalism. What it does is it conjoins what are called foundational approaches in epistemology with what are called consensus approaches or coherentism. So she combines the two words, foundationalism and coherentism, and says that's how knowledge is. And I agree with that, actually, that there is no formal method to the structure of knowledge. So we don't really disagree about that. The points you're making, she's talking about something a little different than what I've been talking about today. What I've been talking about today is how you should approach the study of these systems, not what these systems are. Her point is that what goes on in trial does not look like particle physics, just like I was saying earlier. It's rule governed, and in a sense, she's right. What I'm saying is look at those rules, look at that process, and think about what you think should be done to regulate it. Okay, well, it's overtime. It's late for you. It's early for me still in the morning. Thank you so much for your attendance and for your very interesting questions. Tomorrow we go on to the second important pillar of evidence science, probability theory, okay? Is there
Thank you.
anything else?
Thank you.
Thank you.
Thank you.
Thank you,
Thank you,
Professor.
Professor.
Thank you, Professor
Bye.
Allen.
You're very
Bye-bye.
Thank you all.
Bye.
I'm going to end it. I will see you all, I hope tomorrow. Bye-bye.
See you tomorrow.